Welcome back to Court TV Live. I'm Julia Janae, along with Matt Johnson, who is filling in for Ted Rollins. Thank you for following along with us as we take you to Kentucky now. It's a hearing that's happening that's going to begin any minute. There's a live look inside. This is all for former Sheriff Shawn Mickey Stines. And in the gallery, you can see the victim's family members in the front row right there. The former sheriff is accused of fatally shooting Judge Kevin Mullins in his chambers last September. This was an incident that was caught on surveillance inside of the judge's chambers. It shows Stines and Mullins talking moments before Stines takes out a gun and shoots him point blank multiple times. Yeah, just days before that shooting, Stines was deposed for a lawsuit involving sexual assault allegations of a former bailiff who is accused of having sex with inmates inside that courthouse. Now, the defense cites this deposition as one of the reasons that Stines' mental health was declining in the days and weeks before the shooting, saying he was very stressed about it all. And coming up today, we're expecting to hear portions of Stines' psychological evaluation. It's something that his team actually wants to unseal. They say it's going to support his defense, also help with their motion to dismiss the bond that he has right now, where he cannot get out of jail. And you see him there being walked in his jail clothes. While we wait for court to begin, let's take a listen to something Stines' defense attorney previously said. Actually, let's wait and see if we get any sound from inside of this courtroom, because this is going to be a big hearing. We understand, though, Matt, that it may be pared down. We thought it was going to be all about bond, but it may be changed to a status hearing. And his defense team there that you're looking at, and again, this is all live. We're going to dip in as soon as we get some audio. But his defense team had been asking for bond a few months ago, and they were denied until this psych evaluation was completed, which brings us to today. Let's bring in Mackenzie Joy Brennan. She's an attorney who is standing by watching this. And Mackenzie, this is one of those cases that has shocked everyone. Asking why, I mean, we know so many details about it in terms of what happened, but the why is on everyone's mind. And we may get some answers with this psych eval.
Yeah, I mean, it's such an interesting thing to look at the effect of capacity on criminal culpability, because, you know, almost by definition, anybody who does something like this is unwell. So, like, categorically, psychologically, somebody who does this is not doing okay. I think that also affects the why. We are looking for the reasoning of somebody who is stable, but if we had that, then this wouldn't have happened in the first place. So it's always very interesting. I see everyone standing up, so maybe we're starting in a second.
Yeah, Mackenzie, we're going to cut you off there. Thank you so much. Let's listen.
We are on the record. This is 24 CR 204. I'm with Kentucky versus Shawn Mickey Stines. My name is Chris Warren. I'm the special judge appointed in this matter. Call to identify themselves and everybody counsel table.
Jackie still have call the paper.
Ramsey Dowd on behalf of the Commonwealth. Brother Terry Bartley on behalf of Shawn Stines.
Your Honor, Jerry Bartley on behalf of Mr. Mickey Stines.
All right, thank you. I see Mr. Stines is present. The court took this matter today for the status hearing to address a few matters. I think we'll be in such a position now where we will be able to set some upcoming court dates to get this matter proceeding forward. We have been waiting on a KCPC evaluation to be done on the defendant. That has been completed. It is currently under seal. Procedure is going standard in any type of case such as this. That matter right now is under seal. There's been a motion for the KCPC evaluation to be unsealed. Mr. Bartley, that's the main purpose tonight, as you wish to, if the court does set an evidentiary hearing, the other two motions, you wish to have that as potentially used.
That's correct, Your Honor. Our intention is to have it for the purpose of those evidentiary hearings. I believe that it contains, without speaking about what it contains specifically, Judge, I believe that it does contain valuable information that the court would be able to use, particularly in the bond hearing, in terms of coming to making the court's findings on that are necessary to determine whether Mr. Stines is a good candidate for a bond in this case. And so I think as it pertains to the motion to dismiss, Judge, there's also some information in there that will go directly to some of the testimony that was given at grand jury.
All right. And Mr. Steele, how long, you don't have about a written response to that, you know, how long ago
Judge, if you give us 10 days, I think we got it last week, so if you give us 10 days to respond to that motion. Thank you.
All right. What I would like to do, though, is at least see how far we can get without addressing the pending PC evaluation issue. And in fact, so the court has read that, so that they can keep that in mind. But we can address first the motion to dismiss the indictment. Who's starting?
Your Honor, I will. Judge World of Athens, Your Honor. Your Honor, we filed a motion to dismiss on two grounds. Number one, under RCR 5.16, failure to provide or to have a transcript of the grand jury proceedings. The court knows RCR 5.16 requires that any testimony taken from the grand jury must in fact be recorded. Now, we kind of came upon that surreptitiously. We were listening to listening to the grand jury tape, and there was a reference. Your Honor, I don't know if the court has made that grand jury. Can I speak to the content of the grand jury aside from what I think?
Yeah, Judge. The first record, the court has provided a transcript of TV recording that we used for.
Thank you, Your Honor. So there's a reference from one of the grand jurors that said, in our last meeting, or in our previous meeting, and I'm paraphrasing. And so, at that point, we weren't aware of the previous grand jury hearing. And so I inquired of the Commonwealth, and they did respond to me. The response was basically, well, we met with them, but the purpose was just to get a subpoena for medical records. And the judge, I anticipate that would be the response. But I guess, number one, what's odd about that to me is that I've done thousands of grand jury hearings, and if you want evidence brought to a grand jury, you usually subpoena that to the hearing. I mean, there's no reason you don't have permission from the grand jury to get a subpoena. You send a subpoena, you subpoena the custodian to the hearing. And then the second piece of that concerns me is that even if we presume that is what was going on, and I don't know, there's no recording, but if we presume that's what's going on, unless there was some sort of, telepathic thing going on, there had to be statements made to the grand jury that said, hey, this is this case, this is what we know. And I think the Commonwealth's make the distinction that, well, if you don't come in and raise your right hand and swear, it's not testimony. Well, actually, the distinction is it sworn testimony, unsworn testimony. And I'd submit to you that the only way that if you're asking for a subpoena and you're basing that on some sort of probable cause or evidentiary standard that you want the grand jury to consider, which is the only thing that makes sense. You have to tell them something. They didn't walk into the grand jury room.
All right, we're going to bring the audio down in there. We understand it is a little bit difficult to hear. The microphone placement inside of that courtroom is a challenge. So just to update you on what we've heard so far, the judge briefly touched on this motion to unseal the psych evaluation. He knows that the defense wants it to dismiss bond. And then he moved on from that. It doesn't seem like he made a ruling on it. He wants to see how far along they can get without it. And now they are on the motion to dismiss the indictment.
Yeah, and to that, the motion to dismiss, the state of Kentucky asked for 10 days before, reaching a decision on this from the judge. And, it's also very interesting. I know that we're talking about the audio, but it's also very interesting to be in that courtroom. I think it's the same one that I was in after his initial arraignment. You can see very divided, so many family members for the beloved victim in all of this, Kevin Mullins, the the judge who was murdered in his chambers. That's his daughter's in the front row. Let's try to listen back in.
As to the second portion of my motion, it's based upon Coleman v. Baker, and Mr. Cox actually handled Mr. Baker in that case. We all know it in the prosecutors community is the aluminum bat case. Detective goes in, testifies, and says, basically there was an aluminum bat used. This woman used aluminum bat. In reality, it was a wooden stick or something of that nature. And in that case, when the following conviction and an appeal based upon that testimony being misleading, the Supreme Court sent it back and said, look, if you give evidence to a grand jury, you can't mislead them. And in this, the bigger debate really seems to be after that, does it rise to prosecutorial misconduct, which should stamp it with prejudice, or is it not? And to me, that falls into the without you represent to the grand jury. And so when I look at the grand jury transcript, Judge, again, without getting into the KCPC report, one of the big things that bothered me was the grand jurors. First of all, they spent nearly half the time asking questions. And a large portion of those questions concerned the mental health of Mr. Stines. And the last question before the grand jury retires for deliberation was, so he was in a sane mind as far as the investigation has gone, and the answer is yes. That's Detective Stamper testifying. Now, first of all, probably not an appropriate thing for Mr. Stamper, Detective Stamper, to give an opinion on, but the rules of evidence, I get it. I mean, if there's an evidentiary issue, that's not what we're talking about. But here's the thing. If you're going to let a detective testify about sanity and render an opinion, that grand jury takes that to heart. He's seen all these facts. And I submit to you, without getting, I can't reference the report, but I'll say this. You're hard-pressed to find much in the way of the investigation that would support the adverse opinion. And so this is what I believe. I believe that had they not been told by a prosecutorial stamped witness, someone from the government, that he was sane, they wouldn't indict this case. Or at least they might not have indicted on murder. And so what I think, Judge, is that even if the court didn't find that this arises to a level where this case should be dismissed with prejudice, which is what we would ask, at the very least, I think this thing should be remanded back and sent back to the grand jury and let them hear the correct evidence. Would that statement be corrected, or at least take it out? I mean, I don't think they have to put on evidence that's exculpatory for us. And I don't think that they can let somebody opine to what an expert would say, even if it's a layperson. But if you do that, it can't be wrong. That's a pretty risky thing. And here the investigation, it definitely didn't show he was in the same mind. And there's other additional issues, Judge, and that's one of the things we want to have the evidentiary hearing for, is to ask about all these statements and what the detective had in terms of the investigation. We want to put that on for the court to show why we believe that was misleading, in addition to anything else, Judge.
And I do believe you agree it would require bad faith for jeopardy to attach.
Yeah, I mean, Judge, I think that in the Baker case, they said it'd be reckless. I mean, because basically, and I do think it's at least reckless. But I think we need to hear more about what Detective Stamper knew. What he knows now doesn't matter. I get that. It's irrelevant, right? But what he knew the day he testified is very relevant. And
This is a big day for this case there in Kentucky that's playing out, because the bigger issue is whether or not he's going to get bond. And we're also going to hear about this psych evaluation, which is also part of the reason why they say they want this to go back before a different grand jury, because they say that these charges wouldn't have been brought in the first place had they not been told certain things by a detective.
Right, a detective weighing in on sanity when that's something that they say now this psych eval is going to discredit. They also say there's a question of whether there was a recording properly of that grand jury testimony. Let's get to our break. When we come back, we'll have more of this hearing out there in Kentucky for former Sheriff Mickey Stines.
Tonight, on closing arguments, a Kentucky sheriff caught on camera shooting a judge inside his own chambers. We'll bring you the very latest from today's big hearing.
Closing arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
Saturday nights on ION
is our night.
Let's go! Double headers every Saturday at 7 and 10 p.m. Eastern. The new Saturday Night Out is on ION all season long.
Let's go back inside of that Kentucky courtroom where a former sheriff, Shawn Mickey Stines, is inside of court as the defendant.
Yeah, he's accused of fatally shooting Judge Kevin Mullins in his chambers last year.
Now we're listening to arguments between these attorneys in front of the judge as they're right now, the defense, asking for a brand new indictment. They want this remanded back so the prosecution can do it all over. Let's see what they have to say.
Showing's in the same mind, yes. I think there's at least enough there, Judge, for let me put the witness up there and ask him.
Right.
And then, Your Honor, there are additional items that I think are also of concern. There's a question.
You cited those in your brief.
I cited those, Judge, and those are additional items. And if the court doesn't want me going about each instance, I'll just say that is the sort of thing that I think we need to know from Detective Stamper. If you knew these things, why did you answer this misleading way? And I think it's reckless at best. And I don't know. We need a hearing to find out, Judge, what I'm asking for. Unless the court wants to certainly take it under submission and dismiss without an evidentiary hearing, we would request that as well, Judge. But if not, then we'd ask to be able to put on the
Sure.
Thanks, sir.
Ms. Dahl.
Thank you, Your Honor. Your Honor, the Commonwealth is of the position that we certainly acted in compliance with the rules of criminal procedure here, the rules specifically that were cited by defense counsel. And we would ask that the court to dismiss the motion, to deny the motion to dismiss the indictment as it's wholly without merit. Your Honor, here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records. That is a power that the Commonwealth does have. However, in taking an extra step in the interest of transparency, as the grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, we appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared at that time. There was no witness. There was no testimony presented. Counsel, again, is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded.
Who appeared from the Commonwealth when that request was made?
Myself and Mr. Steele.
Okay.
Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth.
Right.
And so, Your Honor, the rule is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented at this time. And I think that is apparent. The court now has a copy of the actual recording of the grand jury proceeding for the testimony that was presented on November 21st, the only time that testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth response that has been filed, will show, based upon the questions that were lodged by the grand jurors, the only thing that was requested at that time were this grand jury subpoenas for those medical records. I think that's reflected in the context of the recording of the grand jury presentation.
And as an officer of the court, are you representing that that was the only request made?
I'm sorry, Your Honor.
Are you, as an officer of the court, representing that was the only request made?
Yes,
There
Your Honor.
was no peripheral commentary or anything of that?
No, Your Honor. Just specifically request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Mr. Steele,
Just a point of clarification, if I understand your question. As you can imagine, nobody in the grand jury room needed to be told what case this was or anything regarding the fact.
I would think that's a safe assumption.
When we went in and we said, we're the special prosecutors in this case, we're here just so we can get a grand jury subpoena for mental health purposes. They began asking questions of which we did not have an answer to.
Right.
We never answered any substantive questions other than that. That's something we're looking at. That's part of the investigation. Those matters will be presented to you later. There was never, of course, at this point in time, the preliminary hearing had already been had. The video was already out. Other videos had been released. There was nothing we added at all to or any conversation regarding the case other than the investigation and why we needed the records. That would have been it.
Go ahead, Ms.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested and as far as the grand jury subpoenas in writing, which was authored by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued. The records were received. Those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery period. So in compliance with our discovery obligations, Your Honor. So the Commonwealth believes it's clear based upon the rules of criminal procedure that we acted in compliance with those rules. We have additional arguments as far as in the Jackson case. However, the Commonwealth does not feel it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the.
I've read your motion, or I've read your response.
All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has. So no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what Detective Stamper testified to and the questions that were asked during his testimony to the grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation. Additionally, the rules of evidence, particularly Rule 1101, does not says that the rules of evidence do not apply to grand jury proceedings. So hearsay, opinion testimony, the right to remain silent, all of those things are not required to be adhered to at a grand jury proceedings. If they were, our grand jury proceedings would be the same length as a criminal trial. It's not tenable.
The reason a grand jury proceeding for 30 minutes is the same as a 3-week trial.
Exactly, Your Honor. And so I believe counsel's arguments are confusing the two, the purposes of the two. You know, hearsay is presented routinely at grand jury. Opinion testimony, such as Detective Stamper's testimony, is presented routinely at grand jury. These are commonplace and they are permitted under the law.
You would agree, though, you can't be intentionally misleading.
Absolutely, Your Honor. Certainly. And, Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpired when testimony was presented to the grand jury in November is captured on that grand jury recording. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired because it's on that recording, Your Honor. And so we do not believe that an evidentiary hearing is reported or is required. Sorry, Your Honor. So, Your Honor, again, the court has that grand jury recording. We would ask that it be filed under seal as it was a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on our pleadings submitted as well, Your Honor.
Thank you.
Your Honor, may I just briefly reply, Your Honor?
Yes.
Yeah, Judge, so I mean, I haven't confronted anything. I said from the beginning, Judge, I understand. We're talking about the rules of evidence. The reason I cited to the issues where.
All right, we're going to hit the pause button right there. Let's do this. Let's bring in our guest for this hour, trial attorney Mackenzie Joy Brennan. What sticks out to you so far from what we've heard?
I think what the prosecutor said was exactly what I was thinking throughout the defense attorney's argument, that these are things that, purposes that are served by the fact finder in the trial. So not in the grand jury. These are not things that have to come out in a grand jury. We wait until we get to the trial jury to determine things like, was he of sound mind in an expert capacity? As far as the opinion that the detective gave in the grand jury, I would say, yeah, I assume he's of sound mind because he's carrying out this pretty important job, which was providing security and care to the judges and courthouses. So that alone is enough to make a layperson opinion. He also wasn't holding himself out to be an expert in psychiatry or medicine. And I think a competent grand jury would understand that and an opinion coming from that. So ultimately, was it even determinative of what the grand jury came out with? Probably not. I think this is probably a last-ditch attempt from the defense to delay.
Great point that he was a sheriff up until the point that he pulled the trigger. He was someone that everyone viewed as someone in a position of respected power.
And you would think competent when he's dealing with cases, inmates, and court security. And, you know, what we were discussing off camera is like, at what point, if you're the defense and claiming mental defect, does that take effect?
And what is a detective in a layperson's position, essentially, when it comes to psychology, what are they going to say when they are asked that question?
There's a lot more that's going to unfold in all of this, including the defense response when we come back in the sheriff shoots judge murder case playing out in Kentucky for this guy, former sheriff Shawn Mickey Stines. Welcome back to Court TV Live. I'm Matt Johnson, filling in today for Ted Rollins alongside Julia Janae. Thanks for being with us. Let's head back now to Kentucky, where we have been watching a motions hearing, a very important one for Shawn Mickey Stines.
This is one where police say that Stines, who was a former sheriff, walked into a courthouse last September and fatally shot a district judge, Kevin Mullins, inside of his chambers after the two seem to be having an argument.
Yeah, so right now we are listening to the parties argue over a defense motion to dismiss of the indictment against Stines, the grand jury indictment. Let's get you back into the courtroom.
Well, he wouldn't come in is because there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for and it was shut down. I was contrasting.
That's not unusual, Mr. Barr.
Oh, I feel that. I get that, Judge, but my point is this. If you put that into context with what they let testify, then I think ultimately, Judge, if we put on that evidence, it'll show you that this grand jury was misled. I mean, the statement, to be honest with you, the statement alone, rendering an opinion on saying is completely, in terms of, I get you don't have to be an expert, Judge, but if you say it, you can't mislead. And then, so I'm not asking the court to look at whether things should have been admissible or not. That I'm not at all. My point is that the grand jury is an investigative body, and they don't get to dictate what they hear if the grand jury's asking for additional stuff. So in other words, if they ask a question and it's germane, and I'll talk about relevance, but if it's germane, it's their grand jury. It's not common attorney's grand jury. They're the investigative body. And so the reason I cited to the things that I thought should have came in is that it contrasts with other things that I think they asked and never got told because the questions were reformed. And that's why we're asking for the.
Well, thankfully, I've been part of about 20,000 cases being presented to a grand jury.
Sure.
I'm going to listen to the recording, and I'll be happy to review that.
And if the Commonwealth,
Please, sure.
Thank you. I would like to make a distinction. The Baker case, we're talking about misleading to the extent of an aluminum back versus a wooden stack stick. I don't think there's nothing even alleged in the pleadings, even if you take everything in the pleadings that's been said today by the defense as true, that would be tantamount or even close to that, Your Honor. You know, as far as the mental state of the defendant at the time of the offense, That wasn't even an issue at the juncture of grand jury. That hasn't been raised since by the defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask that you deny their motion to dismiss in its entirety.
Understood. All right, and I will get an order out on that. One, if I need to hold an evidentiary hearing in it. If not, I will on it appropriately and distribute that. After review, I've got the CDMS, Madam Clerk, place that under seal with the conclusion of the hearing. I am going to take a copy of it with me to review for purposes of reviewing the plea.
Yes, sure.
All right. Next, in regards to the bond hearing.
Yes, Your Honor. Again, Carrie Bartley for Shawn Stines, Judge. And we filed our motion for the court to, and it's been back quite a ways now that we filed that, but we did ask the court to kind of hold on.
Which is not abnormal. I know we've had some procedural things and evaluations, so.
Absolutely.
That is something that had to be done.
We asked the court to hold off on setting it for an evidentiary hearing until after we received that report back. Judge, I think pursuant to criminal rule 440, I believe it is, we're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring witnesses. We have some witnesses lined up. And I think it would be necessary for the court to hear that evidence and make its findings on whether there are several factors by statute that the court has to consider when determining whether the bond is appropriate. And there's an added level here, and I anticipate the Commonwealth will argue that Mr. Stines is not entitled to bond because of the way that this case is charged. Okay, so in that situation, Judge, they're going to have to put on proof. It's actually their burden to show the court if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden if they're trying to preclude him from bond at all to put on proof that guilt is evident or the proof is essentially, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have a case of an argument on bond.
What would be your proposed bond in light of the circumstances?
Absolutely. And given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at is what he could reasonably post. We would propose.
Public safety is a factor also.
Absolutely. There are several factors, Judge. I just think that in terms of what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So our proposal, Judge, would be $50,000 cash for property with any non-financial conditions that the court would require of him. The court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Stines, and again, without waiving any of our, any of our ability to put on proof, I would ask the court to take a look at the fact that he is, the lowest possible risk level that one human can be in terms of his pretrial.
Pretrial risk assessment, with all candor to all parties, is something that, as a prosecutor, now as a judge, I don't have the utmost faith in.
I understand, Your Honor, but it is also something that the statutes require the court to take a look at. And there has to be some other evidence that the Commonwealth can put on or some other evidence in front of the court that he would be a flight risk, that he would not return to court, that he would be a danger to himself and the community. And again, I think that's why it's important for us to be able to put on proof and to be able to put on some of the stuff that's in that basic piece of the report. I think that when we are able to show the court what's in there versus, all of the other things, I just don't think there's anything to show that he's a flight risk. There's nothing to convince the court that he would be a danger to himself or others. And I understand why we're here, Judge, and I get that. But the courts have said consistently, and it's, I believe, the Abraham case, that you have to look at something other than the charge.
I
It has to be
understand.
something else, right? We can't just look at the charge defense.
But that can be factored in.
Absolutely. So, Judge, I think we're going to need that testimony and we're going to need that report. I would ask the court, again, without waiving anything, I would ask the court to consider setting a bond. The court, of course, can do that at any time. And that would be our requested bond, $50,000 cash or property. If the court wants to hear just a little bit about what we would put on, Again, Mr. Stines is a member of this community for his entire life, born and raised here. He has a great deal of family support through all of this, as the court can see. He has a wife and daughter that he can still go home to today.
The defense is hanging a lot on this evaluation. They want the court to look at that psych eval versus the premeditated murder charges that are pending against the sheriff.
Which is really interesting to have these two arguments back to back, because we're going to say, we're teeing up our insanity defense or defect because of this psych eval and snapping in a moment, but yet he's no danger to the public.
Also let him out so that he can be in the public while he is awaiting this trial. We'll see how the Commonwealth of Kentucky responds to this request for bond and to delay the evidentiary hearing that will ultimately decide that bond.
Tonight, on closing arguments, a Kentucky sheriff caught on camera shooting a judge inside his own chambers. We'll bring you the very latest from today's big hearing.
Closing arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
There's some magic right there. Friday nights, the WNBA is on Ion. The Mystics battle the Feet. She was feeling it. Then, the Mercury hosts the Aces. Let's go, Aces. Coverage begins tonight at 7. Find Ion wherever you watch. Ion, it's on.
Should a sheriff accused of killing a judge in his chambers get bond? We're in Kentucky, where we're following a motion hearing this afternoon in the case against former Sheriff Shawn Mickey Stines.
The former sheriff is accused of shooting and killing a Kentucky judge, Kevin Mullins, in his chambers last year.
Let's get you back into the courtroom now for more of that hearing. We're picking it up right where we left off, where there is a discussion over whether the evidentiary hearing about bond should be delayed.
For basically his entire adult life, up until the point of his arrest, is a respected member of law enforcement, a respected member of the community. And frankly, Judge, everything we've learned about him since then corroborates that. And I would have testimony to that. There's no evidence that he would be a flight risk. Nothing. He has no failure to appear on his record. He has no, property in the Bahamas that he can run off to. There's nothing. This is a man with a great respect for the law, and he's built his life around upholding the law and serving his community. Just there's nothing that I've seen that anyone's seen. And frankly, what we put on our proof of the court will see, there's nothing to say that he would not return to court. There's nothing to say that he would commit another offense. There's nothing to say that everything in this pretrial services report, respectfully to the court, is not correct. That he's a low 0-0 risk, Judge, because this is a man who, again, there's, with all due respect to the court and to everything that, for the reason why we're here, the court does have to look at something other than the offense charged. I know it's a good one.
I understand that, but this, you would have to admit, is a unique fact circumstance.
Absolutely.
This is not a whodunit. The actions are very evident. What the end result of that is, that's the purpose of the case that we're proceeding.
Yeah.
So, all right, I understand your argument. Still.
Your Honor, if I may respond, she went through a lot of the statutes. Unfortunately, she forgot the Kentucky Constitution, Section 16 says that all people are entitled to bail unless there's a capital offense. And the word she was looking for is when proof is evident, but presumption to be great. There's just recently in 2024 a Kentucky Supreme Court case on this issue. It was out of Breckenridge County, if I'm not mistaken. The site on that is 2024 WL 298-2769. That is a case in which, much like we are sitting here today, the defendant was charged with capital offenses. The Commonwealth had made a statement on the record they were not seeking death. In that case, that statement made at that point in time, the judge set a bond over the Commonwealth's objection. The Commonwealth then filed an appeal on that issue. Supreme Court come back and did the exact analysis they're asking you to do. And basically, what he did in the community, what he did is irrelevant. The only thing that's relevant is, in fact, the charges themselves. And the Supreme Court said, if you are charged with a capital offense, you are not entitled to bail. And they overturned the circuit judge and sent it back to no bail. So there's a case law already out there the Supreme Court issued last year. I gave the citation for it. And the case number on that is, or the case name on that one, I don't think I gave you that, is Commonwealth versus Rodney Jones. And Judge, there's enough in the record already. You can take judicial notice. That's why the Commonwealth introduced the video here at the preliminary hearing. It's very clear what happens in the preliminary hearing. They were counsel of record at the time, so there's not an issue. They did the cross-examination of that. The record is very clear. The video is very clear. And Mr. Stines, in fact, took the life of Mr. Mullins. So that's all that's required. Even under the case law, the Constitution, he is not entitled to bail.
Your Honor, if I could briefly respond. I do have a piece of case law I can cite here, Judge. It's Burton v. Commonwealth. It is an older case. It's 212 Southwest 2nd, 2010. Judge, it does show that the court can take into consideration the mental state of the defendant when setting bond in a capital case. So if this case was basically where evidence introduced in a hearing on motion for bail showed defendant to not be guilty of murder, but only voluntary manslaughter, in the event that the jury did not find self-defense, the proof of guilt was not evident, nor the presumption, right? So I think the court can take that mens rea into consideration and that mental health evidence into consideration, which is again why we want to do it, we introduce that.
Thank you. In response,
Judge, I believe the case law cited speaks right to the issue.
all right. All right, as with the other issue, like I said, here's what I'm gonna do. Mr. Steele, you said that you all would file a written response on the KCPC evaluation within 10 days. So
On a motion to unseal?
Yeah.
Yes, Your Honor.
why don't we do this? If anybody wishes to submit case law or supplement anything in regards to the pleadings on all three of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your Honor?
Within 10 days.
Yes, Your Honor.
Yes, sir.
And then that'll give us time. I'm going to try and expedite rulings on this, and then we can start looking realistically more at setting a next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date for all parties. So
I have one thing, Judge.
Sure.
Can we do 10 days from Monday, since today's kind of shot? It's
10 days
weekend.
from, why don't we do this 2 weeks from today?
All right, they're wrapping up that trial. The judge is not making any decisions today. 10 days from now, these attorneys will be able to file anything else they need to. Let's bring back in trial attorney Mackenzie Joy Brennan. Mackenzie, I want to know your thoughts on this part of what the defense attorney said. She said, quote, "This is a man," meaning her client, "with great respect for the law." What did you think about using that line, especially when you're talking to a judge in a case where a victim was a sitting judge?
Yeah, obviously, you know, defense attorneys are going to do what they have to do. I did feel like that argument was a bit tone deaf. To your point before the break, it's a lot to have both of these motions and both of the arguments that they require before the judge at the same time, because on the one hand, you're saying, you know, he's so unwell that he shouldn't be culpable for certain things, in essence. And then that's one thing, but is this psych problem now managed to the point that he is healthy? Because management requires a lot of treatment and diagnosis and real getting a handle on what's going on, and that's a lot harder to show. So the last time that he had unmanaged psych problems and was in the community, he coped with whatever issues he had with violence and abusing that position of power. And I think that as a sheriff, even though obviously he's destroyed some of the ties through his actions, he's going to have access to some resources, whether that's, you know, former coworkers, weapons. There's no way they can account for the kind of access that he has because of the job that he had. So I think it's really going to be tough to show, even if we're not just looking at the offense in question, as defense was urging the judge, to show that there's no risk here.
And yes or no, what do you think, Mackenzie? Will he, at the end, be granted bond?
I don't think so. I think you're asking a judge, and even without bias, it's hard not to see it.
10 days, we will know. Mackenzie Joy Brennan, thank you so much for being on with us.